Major funding for this program is made possible by grants from Bank of America, Merrill Lynch, and Perfect Building Maintenance, KILROY Architectural Windows, Inc., New York's Window Company, New York Community Bank, Capital One Bank, Greenberg Traurig, LLP. Additional funding is provided by grants from Akron Gold Brothers, LLC, Briarwood Organization, C.B. Richard Ellis, Cushman & Wakefield, Hal Fettner, Durst Fettner Residential, First American Title Insurance Company of New York, FRIEDMAN, LLP, GEMINI Real Estate Advisors, LLC, Jack Jaffa and Associates Real Estate Consultants, James D. Kuhn Real Estate Institute at Syracuse University, Madison Realty Capital, Massey Knackle Realty Services, Meridian Capital Group, M&T Bank, Muss Development, LLC, the Moinian Group, NEWMARK Knight Frank, ORPHANIDES and Associates, SJP Properties, Sterling and Sterling, Stonehenge Partners, Urban American, W Financial Mortgage Fund, the Witkoff Group.
Hello, my name is Michael Stoller. October 22nd, 9:45 in the morning, the court makes a decision with regard to Stuyvesant Town, Peter Cooper Village, affordable apartments, rent control, destabilization. Everything is a nightmare and turmoil. Who knows? So in order, and nobody's talking about it. So I've assembled today this distinguished group of individuals, bankers, brokers, owners, to discuss what the impact is on the state of residential and the state of financing today in light of the Peter Cooper Village, Stuyvesant Town case. My guests today are Gino Motochi, head of all type of lending for M&T Bank in New York City, Bob Knackle, chairman of the board, Robert Knackle, I have to pick it properly, chairman of the board of Massey Knackle Realty, Scott Swerdlin, Senior Vice President, Multifamily and Commercial Lending for Capital One Bank. And last but never least, the man who's been with me many times, Ofer Yardeni, Managing Partner and Co-Founder of Stonehenge Partners. So, Ofer, yes. You've been owning residential buildings since what,
1995.
1995. So what is this lawsuit, this October 22nd lawsuit, have an effect on people like you, owners, buyers of property, and somebody who wanted to buy Peter Cooper Village?
I think that the effect that it has on us as part of the industry, on the residential and the commercial real estate in New York, is that we are right now in one of the major recession ever. We are in a tremendous down market.
Ofer, I heard Moody's economists say 2 weeks ago, you were at the same thing, at the real share, the recession is over.
They can say that the recession is over, but we are in this business on an every day, and we see the impact that we have in terms of rent, in terms of value. And I think to have that law or that court just come now, and it's another major effect that is going to affect the residential and commercial, because it's any news that is bad, it has a tremendous effect. So now, if we were like the economists believing that we are going to be in a recovery, you are hearing pension funds and other institutions that wanted to enter to the market to buy multifamily are saying, what's the rush? Let's wait. Let's see what the court will decide. So those kinds of issues that where they create panic and chaos are not healthy to any industry in any market.
With regard to chaos and industry, Bob, you've been writing recently for this other publication, which I will never recommend. But you've been writing for this publication, and you've been well out there speaking about this. Would you explain to my audience what about this decision, everything about it from your perspective?
Well, Michael, first I'd like to say congratulations on your 9th season. I think you're doing a wonderful service for the industry, and a pleasure to be here.
Thank you.
I think more importantly than the decision itself is the impact
you know
of
what,
the decision.
For the novices who aren't aware, you read in the paper all this, explain what happened. I'd like you to give an explanation.
Okay, well, essentially the issue dealt with what happens relative to luxury decontrol in buildings that have J51 tax abatements on them.
No inside baseball.
Okay.
Explain what a J51 tax.
Okay, J51 tax abatement is something that is a tax abatement program that an owner of real estate can get for a variety of different improvements or conversions that are done to an existing property. And those abatements are something that lasts for a period of years. And with respect to the luxury decontrol, that is something that became effective in 1993. There was always a question of whether units that were subject to J51s would be able to be decontrolled or not. And in 1996, the Department of Housing and Community Renewal, which is the DHCR, issued
I have to interrupt because I understand, but I want you to explain to my audience what do you mean by a decontrol department. I think, I just really want to get to the basics so the audience can understand.
Okay.
What do you mean by a decontrol?
It's taking a unit that is rent regulated, either rent controlled or rent stabilized, and removing it from the program by one of two ways. One is a high rent vacancy decontrol, and one is a high rent, high income decontrol, meaning that if an existing rent stabilized unit becomes vacant and the new legal rent were to be above $2,000 a month, that unit is no longer subject to rent regulation, and the owner would be able to charge whatever they wanted to for the unit. The other method of decontrolling a unit would be that if an existing tenant had a legal rent that exceeded $2,000 a month, and they were still in possession of the unit, but they had an income of at least $175,000 for the past 2 years, they would be disqualified from the program based on high income decontrol.
And now the landlord could charge any rent that he wants.
Fair market.
Fair market, whatever the market will
a tenant is willing to pay.
So what happens in October?
Well, in October, essentially what happened is that the Court of Appeals decided that the maker and implementer of the rules of this very complicated rent regulation system that since 1996 has issued orders and opinion letters saying if you have a unit in a building that's
really
getting
from
J50,
1993 to go back.
Well, 1993 is when the luxury decontrol occurred, but 96 was the first point at which DHCR actually rendered an opinion letter on this subject. DHCR implements and enforces the rules and is the rule maker. The HPD is the entity that oversees the implementation of the J51 program. Now, so going back all the way to 1996, you've had DHCR instructing owners, participants in the marketplace, what the rules were. You had those rules ratified by the HPD. You had 2 legislative opportunities to amend anything that was perceived to be not put into place properly in 1997 and 2003. And what the Court of Appeals did recently was said, regardless of what the rulemaker says, regardless of what has been implemented, regardless of what participants in the market understood things to be, we disagree, and basically it created tremendous uncertainty. And that's what we're faced with now, is we're in a tremendously uncertain market.
So essentially 3 governors who followed through. You had Pataki, okay, then you had Spitzer, and now you have Patterson. All the situation, all of this has been, hey, screw it. Whatever happened, happened. I got a new rule now, right? And this related, in reality, there were 9 units 9 apartment owners, renters, who made this case out of 11, how many units?
No, there are 11,200, but 3,000 or 4,000 are fair market.
Fair market. But 9 units, people went to a law firm for a class action to get this case.
Yes, absolutely. But it's not about the 9. It's about understanding and following the law. And really, it doesn't matter if it's 9 people or 9,000.
Well,
the fact is that maybe we as owner did not interrupt the law properly, because for me and as an owner, I have properties in the city, and when I had a vacant unit, I never went and I applied for the J51. I was not aware of the letter of opinion that DHCR ruled in 1996. But to be candid with you, Michael, it didn't make sense for me that in one hand, I'm going to be a decontrol building, and on the other hand, I should go and apply for a J51 that put me subject to rent stabilize. And as I said to you before, we have several buildings that were built under the 421A tax abatement.
Explain to my audience what a 421A is.
When the 421A tax abatement program is a program that was designed for ground-up development, that in order to induce the developer to build apartment building, he entered into a program where he gets tax benefit for 10, 15 or 20 years. And as a result of that, the apartment becomes rent stabilized until the tax abatement expire. And the rent that he is getting as his the first rent that the tenant is going to pay, that become a rent stabilized, regardless
to the stabilization laws which change each year for a 1 year or 2 year renewal.
So we have tenants that are paying over $2,000 that theoretically should be a decontrol because it's over $2,000, but because we are under the program of the 421A, we continue to make those units as rent stabilized and we file. So why would this program...
But on 2013, when the Olivia the abatements, you're going to change the rules.
Of course, because the abatement expire, and if the abatement expire and I'm not subject anymore to the 421A, and if I do not have any more tax benefit, in this case, then I'm allowed, once the tenant leave, I'm allowed to go...
Once the tenant
leaves, I'm allowed to go and to charge fair market value. So why, if I'm at the 421A and regardless to the rent, it can be 2,000 or 8,000, I'm rent stabilized, why would owner think that when they're under the J51, that now they are under rent stabilized, but when I'm over 2,000, I'm not subject to. So I feel that there is...
it became a standard practice.
Standard does not make it right.
Agree, but you know, as they say, perception becomes reality. So owners started to follow what MetLife was doing, okay, and subsequently Tishman. One of the judges in the majority said, in their opinion, where does the DHCR come off questioning or interpreting what the state legislature was trying to do back in 1993? And that, to me, just jumped off the page that the DHCR...
Can I ask the two bankers a quick question? In your period of time of lending to multifamily owners like Ofer and others, have you lent money to an owner to do the J51 major improvements?
Yes.
So you lent them money.
Right.
Did you audit them on how they did this? Did you say, I want you to your rents have to be this? Did you follow up? I mean, I'm not blaming you, but you lent people money to put new boilers in, to do other major capital improvements over there.
But Michael, you can forget about the J51. No bank is auditing our books to see if we are even properly deregulating the units. We are believing that we are doing business in a straight and honest way. So I don't think it's to put the pressure on the banks to have an auditing department.
I am not putting the pressure on the banks. I'm just saying that, you know, prior to the show, we were talking about chaos and questions over here. I mean, M&T Bank is what? What are the assets of the bank?
$70 billion.
$70 billion. Capital One.
$160 billion.
We're talking about $250 billion of assets of two banks who made major loans in the multifamily, many of others, you know, who have a great portfolio. Now you have a situation that we have Nobody knows. You just said there's a dissenting judge who said this. There are other questions. Right. And now they even made it even worse. They said if you want to get monetary, you have to go back to the old courts, right?
Right.
It's in a situation. So how do you now look at a situation to determine if you should make a new loan? Now, you're saying prior to the show that you have this group in your shop who's looking at all the loans. How many multifamily apartment loans do you have?
We have about 2,100 loans, 1,500 which are in the 5 boroughs. And we're going through the process now to try to identify how many of those loans actually have a J51.
What do you think?
Probably about 20%.
Gino?
We've done the analysis. We have about 10% of our multifamily portfolio that is enrolled in J51 in some way, but you have to look unit by unit. This is where it becomes complicated, right? Each unit is subject to its own lease, its own occupancy, and to understand the total impact, you really have to go through the file and understand the latest rent roll and the impact, and then the ruling hasn't been decided yet, so you don't know really what the implications are.
This relates to Ophir's comment. That's not the role of the banker to be going back. You don't even have all this information. I mean, in the heydays of 2005, 6, and 7, when Bob Knackel was selling buildings, overnight, and the flip over there, who even looked at this? You just wanted that rent.
I actually think the direct impact is probably not as significant as what you're alluding to. I think the problem is, what both Bob and Ofer said, is the additional uncertainty in this market, which is already uncertain. I mean, to introduce more uncertainty now, I think introduce a law that has the potential for reducing investment in multifamily properties at a time when we ought to be increasing it, probably.
Yeah, Gino, I agree.
I think that's the real overriding issue.
I think that's a great point, and if you look at the uncertainty and what that does to the marketplace, we have relied, participants in the marketplace have relied on DHCR opinion letters to figure out not only buy, sell, finance, but day-to-day operations. Ofer relies on running his portfolio day-to-day based upon what he understands the rules to be. Once you say, well, what you understood the rules to be are no longer the rules, that creates tremendous uncertainty. And I want to get back to something that Ofer, you mentioned earlier when you said, well, what's the difference between J51 and 421A? I think you have to bifurcate the J51 into two different types of properties. When you have a 421A, the 421A goes on from day one and is done at a point in time which the building is brand new. In J51 properties, you have some properties that become rent stabilized only because you received the J51. And I don't think anybody is disputing that units in those buildings should not come off the J51 and be decontrolled until the abatement period is over. It's the buildings that were subject to rent regulation prior to receiving the J51. If you look at the Stuyvesant Town case, these buildings I think were built in the 40s. They became rent stabilized in 1974. They didn't apply for the J51 until 1992. So, and all of the guidelines that DHCR had issued said this is the way you do it. If you have a unit that was regulated in a J51 building and you qualify for it to be decontrolled, it becomes decontrolled. HPD went so far as to say, okay, well, you've decontrolled so many units, we're going to reduce your J51 abatement because of this decontrol, essentially ratifying what DHCR's position has been. I think this has been terrible. And Michael, when you say, well, the banks are not auditing how owners are operating. I'm not asking them to audit. No, but bankers, you guys, Scott and Gino, you want to understand your collateral. How are you making a loan if you're not understanding the collateral? This is a terrible decision for the market.
So we look at every lease. I mean, we try to understand every
one
lease.
of the credits, there's different collateral, credit, character, and everything. This is the collateral. How do you look at the collateral now? How do you evaluate that collateral when you're looking at a deal?
Well, first of all, we don't even know if it's going to be retroactive or not. We don't. We still there's much to decide. That's going to take some time to decide. It's going back to the trial court, as I understand it. So that's going to take some months or perhaps longer to unfold. In the meantime, I think we do what we do. We go through our file. We take a look at the rent roll, and we discuss it with our sponsors to understand what they believe the impact to be. We've already been making calls. So I've got a client with 2,500 units on the Upper West Side. 8 units are affected. So it's not that big a deal. I mean, of the sort of 10% of our multifamily loans, which is sort of 4% of our overall loans, I think most of that, a good portion of that's with a very well-heeled, well-known family in the U.S. or in New York. And
you know, we all, as you know, I'm on 1010 Wins on the weekend, and sometimes I listen. I want to hear my report, and I hear the commercials. And I heard one, law firm saying, we've been an advertiser on 1010 Wins for 22 years. Now, how do you advertise on 1010 Wins? You advertise basically, are you a victim of asbestos? Are you a victim of workers' comp? Are you a victim? Do you know what's happening now? People are walking into buildings on the Upper West Side, all over Manhattan, and putting leaflets under the door. And that person who never thought that they'd have an accident is now saying, maybe I'll call 1-800-LAW firm to take a class action to sue Ofer Yardeni. I live in 1274 Fifth Avenue. Even though you may have not applied for the J51, I'm going to go to 1250. I'm going to go to this lawyer over here.
Everybody has the right to sue. That's the legal system that we have in the United States. And I'm not afraid, and I'm not concerned about that.
Ofer, I'm bringing out the fact that I'm not saying you're afraid. You haven't done nothing wrong. All I'm saying is now, in the middle of all of this chaos.
No, Michael, but Ofer doesn't know if he's done something wrong or not. He's been playing according to the rules that he understands them to be.
Right.
But he may have done something very wrong because DHCR instructed him improperly, and there may be a litigation that's going to bring this issue out and it's going to overturn what the generally accepted practice is.
I think you've sold Ofer a number of buildings over the years. You've financed property for Ofer, and you've financed. When you bought buildings, now that you may have bought in 1998, 2000, you may have bought a building, there may have been a J51 on certain of those apartments. There may have been something over there.
You'd be surprised, but when we do our own due diligence, and we do very internal, we always checked to see if there is a J51. And I remember clearly on a building that I was going to buy on 2nd Avenue that we had the J51, and all the rents were above 2,000, and we couldn't justify it, and we walked away from this deal. So I believe that there are other buyers that looked at that, and people were concerned because if you are J51, you're unstabilized. We looked at it, so we looked at those all those issues. But I think is that the issue is not as large as people think, and in the next few months people will understand it better, and the atmosphere will be more relaxed, and people will maybe look at it that if a building that is without J51, it is worth premium to a building that is with J51, and depends how many tenants, as Gino said. If you have 8 tenants in a building, you're not concerned about that. If you have 100 units, people are concerned about it.
Stuyvesant Town had 11,000 units. You said it was only a couple of thousand.
Right.
4,000 units.
4,000 is a big number, because you're talking that in Stuyvesant they didn't take it, I think, from 2,000 to 2,200. They took it from 2,000 to 4,000.
The issue with Stuyvesant Town, it was already a failed project. I mean, this only sort of adds icing to the cake, in my opinion.
Which helps, build the momentum of what's going on and the uncertainty. But Michael, you take a bigger picture of the whole thing. Look at all the boroughs. You have low and moderate income neighborhoods. So many buildings in those neighborhoods have J51s where the landlords put the money back in. But you'll see that the average rent in these buildings are probably closer to $1,000, $1,100.
There's no effect on them because it's below the 2,000. I mean, the J51 problem, or this discussion, really is predominantly in Manhattan. Maybe in the Forest Hill section of Queens, which...
It's whenever you have rents over 2,000.
Brooklyn,
right.
So it's really affecting Manhattan.
Right. So you take it a step further. As you said, you have middle-income neighborhoods, Forest Hills, Bayside, Riverdale, the Midwood section, Sheepshead Bay, Bay Ridge, and then that area of Manhattan, from 110th Street now down. And you have to take a hard look at it. Gina and I were talking before, it's not so much, it's going to affect individual landlords and individual units in their buildings, where, as he said before, maybe it's 8 units in this building, 3 units in that building, two in that building. That's the uncertainty, that's the risk. So that's one thing. I think the whole thing with Stye and Cooper is that this has just been escalating in the press. The Times covering it, the Wall Street Journal covering it, you covering it. And it finally built to a head now where you had a lower court decision, a higher court decision, but there's still so much uncertainty. How it affects the landlord, how it affects the tenant. How's the tenant, is he going to file a unfair rent claim with the DHCR? Is that how this is going to be settled? A lot of people think it's going to go back to the court and probably back to the state legislature to figure out a way out of this.
But I thought it was at the final courts. Are they going to over?
The trial court has to decide what the damages are, and whether it's retroactive or whether it's prospective or
the court here only made a decision that it was not done proper, but it didn't speak about damages.
Specifically did not.
No.
Yeah, and I think the issue too is we're forgetting about the small property owner, the building that has 10 units or 15 units. Right. Most of the operating margins in those buildings are so slim that if you have 1 or 2 units in that building, that could put the property into negative cash flow. Because how is the owner going to justify rolling back rent or however they're going to deal with it? And that's the uncertain part. Nobody knows what the court is going to decide will be the implementation of this decision. And I don't think it's going to take months. I think it's going to take years and years, because very likely when the trial court makes a determination, it will be appealed and it's going to go right up the ladder again. This is not going to be resolved for a long, long time, many years.
But the other uncertainty issue is how does this affect the securitization market? He had rulings from opinions from 2 separate law firms saying that they didn't believe that this lawsuit was going to impede the cash flow of Peter Cooper Village.
If we remember, which is exactly what you're saying, when Peter Cooper Village, and we're going to talk about it today and next week on the follow-up show, when people were looking at Peter Cooper Village, including Ofer Yordeni and your investors, everybody wanted this. Nobody was really thinking about this. Yeah, it was a problem, but it's a problem that we can take care of. We have to come back next week to continue on this discussion. I'd like to thank my guests, Gino Martocci, Bob Knackel, Scott Swerdlin, and Ofer Yordeni. See you next week when we continue our discussion.
Major funding for this program is made possible by grants from Bank of America, Merrill Lynch, and Perfect Building Maintenance, KILROY Architectural Windows, Inc., New York's Window Company, New York Community Bank, Capital One Bank, Greenberg Traurig, LLP. Additional funding is provided by grants from Akron Gold Brothers, LLC, Briarwood Organization, C.B. Richard Ellis, Cushman and Wakefield, Hal Fettner, Durst Fettner Residential, First American Title Insurance Company of New York, FRIEDMAN, LLP, GEMINI Real Estate Advisors, LLC, Jack Jaffa and Associates Real Estate Consultants, James D. Kuhn Real Estate Institute at Syracuse University, Madison Realty Capital, Massey Knackel Realty Services, Meridian Capital Group, M&T Bank, Muss Development, LLC, the Moinian Group, NEWMARK Knight Frank, ORPHANIDES and Associates, SJP Properties, Sterling and Sterling, Stonehenge Partners, Urban American, W Financial Mortgage Fund, the Witkoff Group.